Okay, hello everyone. I hope you can hear me. If you can't, make some sort of noise or go in the chat box or something like that. Anyway, we are here today to learn about ISO 27000 and also how to make it security compliant and achieve SEC regulations. This will go on for a number of different areas because it's basically a very broad topic. Let me introduce myself. I'm William Gamble. I'm a consultant with IT Governance USA. I do training for all sorts of privacy and cybersecurity laws. I've also been a lawyer for longer than most of you have been alive. And also I have 4 IT certifications, mostly in cybersecurity. And I very, very much enjoy the entire process of IT certifications and dealing with this type of teaching. This is IT Governance. We're a British firm. Our claim to fame is we were the first company to certify against what was at that time the predecessor of ISO 27001, and we've expanded substantially that in terms of cybersecurity and also in terms of privacy. Like the big thing of privacy right now, of course, you probably have heard of GDPR, but you're going to hear a lot more about a whole lot of different things this afternoon. Anyway, what we're going to do is we're going to look over the cybersecurity regulations, mostly for the SEC. I'm not going to cover state laws or what they call blue sky laws in the area. That's all right. There's probably not appropriate for you. We will probably touch on state laws, and we'll also touch on ISO 27001 regulatory compliance. Now, we will talk about the SEC for those of you who are listed companies. What's a listed company? It's a company that is listed on a stock exchange. But even if you're not a listed company, if you do have investors who are investing their money and do not control how they invest necessarily, how they control the money, then you are under the auspices of the SEC and you must comply. Anyway, we're going to do practical advice now to prove your information, and we'll go over various types of things that are absolutely necessary to make sure that you have the best cybersecurity out there. Remember, as the guy from the NSA once said when I was listening to his lectures, you don't want to be the last gazelle in the herd. Anyway, overview of the regulations. First of all, we're going to talk about SEC regulations. What does the securities law require that you have? The big one here is section 13B2B and I3, which requires you to have a system, and the big here is I3, access to assets permitted only in accordance with management's general or specific authorization. In other words, you don't want to be hacked. So you don't want anybody in there who can, see your stuff. And then you have to have reasonable assurances that everything is working appropriately. That sort of gets into the Sarbanes-Oxley, or AKA SOX, which I will get to in a bit. So this is just the SEC, mind you. This is just for listed firms, for security firms. There are a whole bunch of other regulations, and here they are. The regulations depends on what you do, where you do it, how you do it, and everything else. So if you happen to be a listed firm, like say a health insurance company or a hospital, what's the one around here? I get a Lifespan. I'm not sure if they're listed by something. And then there's all sorts of other listed firms. Then of course you're under HIPAA. So you have to comply with that. If you're a commercial firm like a bank, insurance company, a mortgage broker, even a used car dealership in the state of New York, you have to comply with the New York Department of Financial Services regulations, 23 CRR 500 at SEC. Now, not only do you have to comply with 13, the one I just showed you, 13B, there are also other securities rules. There's the safeguard rule, which is a cybersecurity rule, and there's the ID, the red flag rule, which occurs to everything else. Now, the big one and the sleeper in all this is securities rule 10b-5. Now, what's 10b-5? That means that if you have a material change or immaterial information, you have to tell investors about it. You can't do what Equifax did, is say, oh, we have a breach and it's July, and then 2 months later they tell everybody else about it. That is a no-no. That just cost Yahoo $25 million. I just noticed that there is a mortgage firm in Texas, and they're owned by somebody named Rock Top, which is theoretically a private, but it looks like they have outside investors. And they were hacked for 24 million records on January 15th, and gosh and golly geez, they're just telling everybody about it now on January 23rd. That is not good. That could make the SEC very, very angry. You don't want the SEC very, very angry because they do like to do these things. They will crack down on you. It may not be immediately, but they will take you, and it will be very, very expensive. Okay, those are the federal laws. Now, surprise, 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 we actually have U.S. laws. No one knows a lot about them, but there are all states, all 50 states have breach notification statutes. Now, these vary, of course, from state to state, but you have to be very careful with these because right there, I had 22 states have cybersecurity. No. That's 24 now. So in addition to the breach notification, they have sort of cybersecurity requirements. What do these cybersecurity requirements say? Well, part of the problem is they're very vague. They just say thou shalt have reasonable cybersecurity. Now, I'm not sure what reasonable cybersecurity is, but I'm sure that if you are ISO 27000 certified compliant, you have best practices. The sleeper in this, which is not on the slide, are those 10 states, which, let's see if I have the list here. Yes, I do. It's California, Louisiana, Maryland, Massachusetts, New Hampshire, North Carolina, South Carolina, Tennessee, Virginia, and Washington all have right of private action. What's a right of private action? A right of private action, most of these states that don't have rights to private action, the only people who can enforce these cybersecurity requirements or the breach requirements are the state attorney generals, and they have a lot of discretion. A right of private action means any plaintiff can come in and enforce these rules. So if you have a breach notification and you haven't notified everybody in time, so you violated not only the SEC rules, perhaps the HIPAA rules, perhaps the NYDFS rules, you might also have violated your state rules, and you could get sued not by the Attorney General or by the OCR, the regulator for HIPAA, or the NYDFS. You could get sued by a private party. And let me tell you, there are a lot of private parties out there who would just love to get a class action. So there's that out there. Now, I haven't even got into the California Consumer Privacy Act. It doesn't come into effect until January 1st, 2020. Now, that does have a right of private action to it, and even better, it sets the fee for that. So the fee for that would be $100 per incident. Well, that's not a lot of money, except unless you've lost 24 million records, at which point you owe the state of California, probably all your plaintiffs, a little more than $2.4 billion. And you thought that GDPR was nasty. Oh, no. We're the United States is into it, and have to remember USA. We've got the biggest fines ever. Of course, but now you might do business also not only in the United States, you might do business internationally. Well, you might have heard of the GDPR. What you haven't heard is Article 44 of the GDPR says, if you want to exchange information with Europe, that has to be adequate. You have to have laws similar to the GDPR and that protect users' information. So gosh and golly gee, since the GDPR is the EU, and that's one of the largest trading groups in the world, what do you think all these countries did? Oh, they swallowed the GDPR whole. So you have a whole bunch of countries like Japan, South Korea, Brazil, even smaller ones like Qatar, who have basically India has one. So China is of course China, so they're a little weird, but you have to remember that these laws, the GDPR, isn't just Europe anymore. It's everywhere. Now, that over 10 countries at last count, no, that's like 15 or 16. It's probably going to go to 20 because people, now they're little tiny countries. We got Vietnam, Malaysia, Qatar, Kenya, Bahrain, you name it, they're adopting these things. So these things have gone internationally. So the whole point is United States companies, I know, all you're out there saying, oh, no, we don't have to worry about the GDPR. We don't do business in Europe. Well, you do business somewhere because you're in business. So that means that you are subject to some sort of regulation somewhere, and you're going to have to come up with some method of protecting, preferably best practices. We'll get to that. Protecting your cybersecurity, and in certain cases, you will also have to have a procedure or protocol for breach notification, and you might have to have privacy, depending on where you are and what you do and how you do it. Okay, now here are the two laws. The laws are basically divided into two various types. There's cybersecurity laws and privacy laws. Now, there are some laws that just do cybersecurity. That's all they do. That's it. Like the state laws, you have to have reasonable cybersecurity. They don't go into privacy. There are other laws that are just strictly privacy laws that just have to deal with privacy. And then there's laws like HIPAA and the GDPR that are a bit of both. So you have to look out for various types of things. Now, cybersecurity law, basically the way the regulations are going, the way the legal environment is coming, not just the United States. Also, I might point out that there are 20 draft statutes in the Congress right now, which are being considered. This is a bipartisan issue, and it will probably occur at some point in the year. We're going to get some sort of, my bet is by the time the year is out, we may get a federal law that has to do with various types of things that has to do with cybersecurity and or privacy. I don't know, but it'll be one or the other, or breach notification. So cybersecurity is you have to implement and maintain a what? A risk-based information security. Now, risk-based is basically has taken over the entire field. When you have a cybersecurity law, they're almost always risk-based. Now, there's two ways to sort of do a cybersecurity law. You can create a checklist, like the NYDFS or HIPAA or a lot of these things. That's sort of the American philosophy. You do a checklist, is thou shalt do A, B, C, and D, or you take the NIST special paper 853 and you say, well, you're going to do these controls. That's sort of the SOC 2 way of doing cybersecurity, which in my view sucks. But what's happening in the world, it's becoming a risk-based requirement. So what that does is it says, okay, let's look at what you've got. What would happen if you lost it? For example, maybe you're just have B2B. Okay, you just have names, phone numbers, email address. Well, nobody cares about that. That's been on the dark web for 5 years. So, it's not worth any money. However, let's say, for example, you have all sorts of bank accounts, or maybe you've hacked a very large law firm and when the mergers and acquisitions are going to take place. Well, that is a different kettle of fish. So you have to determine what sort of information you have in order to determine what sort of security you should have in place. If you got B2B, who cares? You don't have to have heavy duty security. If if you've got healthcare information or legal information or a stock exchange, God forbid, you're going to have every cybersecurity process out there. All right, that's cybersecurity. Let's go on to privacy. Now, all these rights and things will change depending on the country and the law. Most of them have the following types of things. They have a lawful use. What gives you the right to use somebody else's junk? Remember, my data, and this has been the law in the United States, surprise, surprise, Google, who just got whacked with a $50 million fine by the Europeans. Surprise, surprise, Facebook and Google and all you guys, that's not your data. No, that's my data. That's my property, okay? That's been around since 1898 was the first time it came up in American law. And if you use it improperly, like, for example, Boleo versus Gawker, aka Hulk Hogan, cost Gawker $114 million because they were using Boleo's personal information and they didn't have permission to do so. Okay, and that's not under the statute. That's just straight common law. So you have to have a lawful reason. It's like you rent a car. Right now, if Google takes my information, they can take it forever, as long as they want. They can, it can be breached, whatever. They don't owe me any money. Well, the reality is what the GDPR has to do. Remember what privacy is. This is a property law, a property. This defines how you can use someone else's property, in this case, their data, and for your particular purpose. Now, quite often, the best lawful use is consent. So I allow you to use my stuff because you give me something, like money. Or there are other lawful uses dependent. And then also, many of these things have rights. What type of rights are there? Well, those are some of the rights you can have. Like have a right, if under certain statutes, to look at what you've got. And I can say, well, I don't want you to have that. I want you to erase it. So, or you can also, another right might be retention. How long do you have to keep my stuff? So that is one of the various types of rights that exist. Now, these vary according to the statute, but some of them are, because the GDPR has had such a significant impact on global law, a lot of these things are very similar. And then, of course, there's Article 44, cross-border transfers, says, thou shalt not take my stuff and send it out of the country unless you got a reason to. And that's why all these countries are adopting these cross-border transfer laws, is because the GDPR requires it. Under GDPR, unless you come within the exception, it is prohibited. And that can get you under the 3 larger fines. Although I promise you, GDPR, unless your name is Mark Zuckerberg and your name of your company is Facebook, you probably will not be subject to the fine. Or Google, of course, now has just been subject to the fine. But other than that, the requirements for the GDPR are probably pretty benign as to you. However, that doesn't get you out of all the other regulatory environments. So it's not just one law you guys got to worry about. It's a whole bunch, depending on what you do. So these are the penalties for various types of things. Now, what I say to most people, when either my clients or my delegates, is don't worry about the regulators. They're not going to hurt you. Okay, the reality is, yes, the GDPR will and can and probably will fine Google 4% of its global revenues, but that probably doesn't apply to you, because there are 11 mitigating factors in the GDPR. So unless you break them on a continual basis, like Google or Yahoo, then you're probably in good shape. Anyway, so the other people here are the other losses actually are from, as you would expect, from the hackers. So, for example, the big one, according to the FBI these days, is they looked at just 9 issuers, just 9. This is the SEC actually, and they came up with total losses of $100 million. That's just 9. The average cost of a business email compromise is 3.86. The old one used to be ransomware, which I'm sure you're aware of, and these days the big one is business email compromises. So what they do is they track usually your CEO or your controller or something like that, and send a phishing email, preferably on a weekend when no one's thinking about it, to send X million dollars to an account in Romania to pay for a merger and acquisition. And this is where most people are getting hit. Now your CM or your super duper next generation firewall or your AI ain't going to stop this type of thing. The only thing that's going to stop this thing is training, some more of that. Anyway, okay, those are the business laws. Now they're fines. Now, yes, I did say that the odds are not great. However, if you do get fined, they're going to be big. As I just said, Google right now is on the hook just to France for 50 million. I'm sure there are other supervisory authorities in the GDPR get on board. Voya Financial Advisors, Uber lost 144 million to the states. That's not federal, that's just the states for their boo-boos. So Voya got hit by the red flag rule for $1 million, Morgan Stanley, red flag another $1 million, and then there's the various types of other types of law enforcement. And then, of course, then finally, the goodie is the criminal investigations. For example, in the case of Equifax, there's a whole bunch of insider trading that went on, and those people are probably going to see the inside of a federal prison for a little while. So, you know, it also depends on what the other states and the other countries do have laws that sometimes are criminal. So hopefully you will not see the inside of a Japanese penthouse or penitentiary, unlike Carlos Goshen, who might have that privilege. Okay, now, how can ISO 27000 support this? Well, first of all, the whole reason ISO is better than anybody else, in my view, and I drank the Kool-Aid on this one, is because it's an international standard. But first of all, what is ISO? Well, when I was getting my CompTIA certification, the CASP, Advanced Security Practitioner, I thought, oh yeah, what you do is you look at the list. You look at 853, and you go down the list and you pick out what you like, and the more you have, the better off you are, and that's how you do it. Well, that's nice, but unfortunately, it doesn't work. What ISO is, it's so different. It's not a list. It's not like SOC 2. It's a management system. It's like ISO 9000. What's a management system? Well, let's see. I drive a Japanese car. Why do I drive a Japanese car? It's because the quality's better. Now, how did that happen? Well, there was this guy named Deming, and Deming was trying to get General Motors to improve its quality. And General Motors said, why bother? We sell a whole bunch of cars in the United States. What difference does it make? Anyway, well, Deming got hired by the Japanese. In those days, Toyota was a little funky little car, and they only had one headlight in the front of it. So, but they wanted to expand, all right? So they hired Deming, and Deming gave them basically the plan, do, check, act cycle, which is a process of continuing, it's a management system. It provides continual improvement. So what the point of a management system is, as opposed to like a checklist system, is because it improves, all right? So why use them? Well, if you're trying to constantly improve your system, if you're using the system properly, it'll constantly improve. That's what the point is. They'll work. And they'll get into the number of the main reasons that work together. Okay, why do you want to use them? Because the costs of not using them. Because you may get hit by a fine or hackers or God knows what, and so then you won't be in compliance, and the SEC will come knocking at your door along with every other investor. The problem with the SEC comes knocking on the door, it's not just the SEC, then you've got derivative lawsuits. Remember those private actions? Well, these are private actions. They're a bunch of very mad and very well off, very well heeled investors, and they could come knocking on your door and ask for money too. Okay, the other big reason is the digital supply chain. Information is, information is knowledge. Knowledge is value. Does knowledge have value if we keep it under the rug? Well, in certain cases, yes. If it's intellectual property, we don't want to share it. But most knowledge, and the reason why Google and Facebook are multi-billion-dollar companies today, is because they share information. All right, if you share information, then you've got another problem. You've got a digital supply chain. So you don't have to worry. You don't have to worry just about yourself, and you've got to worry. It's like Target. They got hacked because their HVAC their supplier, didn't have a secure system. So your whole problem right now is the digital supply chain. Well, how do you check on the digital supply chain? Well, there's a bunch of methods. One of these, you could pay for a second-party audit, but you'd have to keep doing that. So what's the reason why you do the ISO is they say, well, it's a certification. Look, here it is. Here's my certification. And we'll get into why that is. Okay, management systems forces people to do, first of all, consider the business requirements and material risks. Remember we talked about material risks when we were talking about how these laws are drafted these days? Well, clause number 6 says, and clause number 8 says, thou shalt determine what your material risks are. What sort of cybersecurity system will depend on what you've got. So once you determine that, then you can go forward because you're working on empirical objective evidence, and then you can make a reasonably informed decision about the cybersecurity. You don't have to go into this into the CFO's office and say, "Oh, gee whiz, look at this zing-zang CM out here. I really want that." Well, well, do you have the budget for that? Well, I don't know. Well, do we need it? Well, that goes back to your risks. If you know what your risks are, you know what you need, and you can justify it in the budgetary process, and that will give you a better possibility of getting funded for these things, which all of you know is a very hard thing to do. Okay, it also identifies and prioritizes cost-effective improvements. Do we really need this one? Well, let's prioritize it. We may not be able to fit it in this year's budget, but over time, if we have a method and we're trying to do these things, we're trying to constantly, and the big word here is monitor, because people are going to screw up. And that's why you want to constantly monitor. You don't want to go in and if they fail something to, take them out and strap them to a post and whip them. You want to make sure that your policies and procedures are understandable and that people are actually following them. Because if the procedure is good and people actually follow it, then you are in good shape. And you have something also, but you want to constantly try to improve it, make better procedures, get better, people do agree with to go forward. So what it does, the management system satisfies the client mandate, also satisfies your regulatory mandate. Remember 13B111, whatever. That requires that you have those things in place. It increases your marketing potential, allows you to say, oh, well, we're cooler than the rest. For example, I'm on the tech committee with the Florida Bar, and the Florida Bar is going to implement something called a blue ribbon law firm. I assume a blue ribbon law firm is something that has a hardened cybersecurity. Well, how do you prove that? Oh, here's our certificate. Is there any other system you can certify to? No. So it provides your competitor, look, we're a blue ribbon law firm. We've got our certificate right here. So, and I've audited law firms and their clients are terrified because that law firm has some very valuable information. So they got sick of doing, the second party audit because they got too expensive and taking too much time. So they just said, all right, we'll certification satisfies regulatory requirements. This is best practice. Articles 42, 43 of the GDPR sort of imply that we want something that's going to be certified to. And I don't think they're going to reinvent the wheel because ISO has this massive, ISO's got regulatory and certifications for everything under the sun. I'm sure they got one for an outhouse somewhere. Best information security management practice. This is, best practice global. And it also gives everybody insurance, especially if you're dealing with the SEC, you've got to make sure that your investors have assurance on your security, especially if you're a dangerous business like banking or brokering or any of those businesses, because then you have to make damn sure that all your investors and all your partners are secure that no one is going to come in and make off with $100 million. And as we just saw, that happens on a regular basis. Okay, now most of you, if you're in the security business or have to comply with Sarbanes-Oxley, you've probably heard of SOC 2. Okay, I can't maintain that I am an adept at SOC 2. I have read IASE 34102, 3402, and basically what I get out of that is that the auditor comes in and looks at your system and says, is your system, the system you've got, working the way you think it's supposed to? Well, that's cute, and that's nice to know, but the problem is that it's not a specific standard. It's basically a checklist. It's like PSI, DSS, or 45 CFR 164-300, which is basically says you do this, this, and this. Well, the question is, unless you've gone through the entire process of planning, you don't know if you need to do that, that, and that. So that, or you might not need to do this, 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 and then you might want to do some other things. Now, the whole point of going through a management system and is in order to comply with these laws. First of all, it's really easy. Let's, for example, Ohio right now has put in a safe harbor. You can't get sued if you comply with, a whole bunch of like system like NIST, CSF. Okay, we comply with NIST CSF. Okay, I get sued. Plaintiff comes in and says, all right, what do you have do you have a system? We say, yeah, sure, we got NIST CSF. And so the plaintiff says, prove it. So that means you got to battle the experts, because my experts are going to say, oh no, they don't have it. No, they don't have it. And the defense expert says, oh yeah, we got it. You know, we got this stuff here. Okay. The great thing about ISO is they go in and say, all right, where's your system? Prove it to me. Oh, here's my certificate. Hey, look at this. Okay, at that point you get a motion to dismiss. You come within the statute, you come within the safe harbor. No one can prove otherwise. You know, you got the certificate, out of court. End of story. Okay, so that's why it's having the management system, the constant improvement is better than checklists, because it's easy to prove. It's certified. The next thing we've got is audit. Okay, now the thing is about the checklists or NIST CSF is it might be NIST CSF I'm taking a look at. There's nothing wrong with it. All right. The problem is that nobody checks on you. I don't know about you, but unless somebody checks on me, I might not be doing what I'm supposed to be doing. So, you have to have somebody come in and say, well, are you doing this? Are you doing this? Are you doing this? These ISO 27000, SOC doesn't do that. All they do is they send someone around, when they have to have sign the statement as to whether you're basically SOC 2 was developed not by IT people, a panel of experts developed by a bunch of CPAs. And SOC 2 is part of the American Association of CPAs SSA 18 requirements. But it just says, okay, well, you got these systems, you chose these systems, and it seems to work. Well, why'd you choose these systems? There's nothing, there's nothing in there about that. There's nobody checking on you on an annual basis. ISO 27 requires certification audits before you get a certificate. They require annual audits by another body, and then they require internal audits, and then you get your happy piece of paper. It's something like, well, how do we know you went to law school? Well, here's my certificate. How do you know you're a certified advanced security practitioner? Here's my certificate. I just, I show that. Yeah, that's, you don't have to ask any more questions, because that's what it is. So you can go down the digital supply chain, and the next person in line is, has as good quality certifications and as good quality cybersecurity as you do. And that's great for marketing, because you can say, hey, look, we're a better contractor. Yeah, we may be more expensive, but you be damn sure can see our certificate that will watch your information better. Okay, it's an international standard. NIST and CFS and all that stuff is just the United States. ISO 27000 is everywhere. Okay, who has the largest number of ISO 27000 certifications? Japan. Who's number 2? United States? No. Germany? No. UK? Well, UK's out there, but who's number 2? Guess. China. Why does China have an ISO as the biggest certifier for ISO 27001? Well, what do we negotiate with China about now? We're talking about the massive theft by China of American intellectual property. I've been writing about this since 2009. Anyway, so the Chinese say, wait a minute, how are we going to make sure that our intellectual property is protected? Are we going to let somebody else steal it the way we do? Oh no, let's protect it. So how do they protect it? ISO 27001. So, and the problem is a lot of Chinese companies, a lot of people don't know this, but the most of China's industry are actually state-owned. Remember, it's communist China. Okay, so a lot of these state-owned companies, so the people who own these companies, usually local governments, don't want their stuff stolen. So they have picked the best international standard they possibly can. And who better than they would know how to break into another system? So that, that's your proof right there. Okay, it's the only framework it's internationally accepted by the Chinese, of course. That's your stamp of approval right there. And then manage confidentiality, integrity, and availability of data. What ISO does not do, and this is the caveat, is it's not a privacy, it's just cybersecurity. If you want privacy, you go with ISO 29100 or the British standard 1012. My preference is 29100 because it's an ISO standard. The great thing about ISO standards is designed to be adaptable to anybody, anywhere. So they can adapt to your industry, and it doesn't matter whether you're a 4-person firm or you have 130,000 employees. It works for everybody. Or if you're Chinese and you're trying to protect yourself from American hackers, good luck. Okay, cybersecurity privacy regulation requires demonstrated compliance. Remember I talked about going to a law court and say, all right, you got NIST CSF, prove it. All right, so now you're now you got to prove it. International standard best practice. It ensures confidential information. This is basically making sure that your digital supply chain is in great shape, is adaptable inside business, and it provides. What the great thing is, because a lot of the state statutes, the 22 that have cybersecurity statutes, say you want to have reasonable and appropriate cybersecurity. Well, if you've got an international standard, then you've got a reasonable and appropriate cybersecurity. Okay, so these other benefits, independent assessment of your security posture. That's really important. You want somebody else coming in. You don't want to say, well, we made this up at the time. You want somebody else to come in and say, oh, yes, they are good. It improves the firm's culture and focus, et cetera, et cetera, et cetera. It's not, it's not cheap, but then again, your fines won't be cheap either. So those are some of the benefits of your cybersecurity process. Where are we now? Okay. Practical advice, right? All the way down there. Okay. These are basically the way you create an informational management system. It could be anything ISO, but I think you have to create a management system in order to make sure you comply with 13, because that says you have to have something that protects the confidentiality, integrity, and availability of people's information. And it's not just the SEC, as we've seen, there are so many other laws. Okay, these are basically the categories, many of the categories. Management support, you have to have leadership. So that you have to have, you really, each and every one, I assume most of your IT people, most of my delegates are almost always CISOs and things like that. And the main problem is making sure you get management support. Now, the reason I've been giving you all these laws is that's one way to scare the bejesus out of management and get the money. My favorite story is the international shipper. I'm not sure I'm going to pronounce this as Maastricht or Maersk. Maersk is it? Basically, they have all those containers you see on the highway, Maersk. Anyways, you probably know, because they had, they didn't segregate their systems, and they had a lot of legacy systems. They had one person in their Odessa office who uploaded a local accounting package. Now the Russians, because it was Ukraine, the Russians had a back door into this accounting package. And as soon as they hacked it, the NotPetya worm went through their system in a matter of hours. And it would have told, there was a 10-mile line at their Newark shipping container, because all the barcodes operated the gate that went up and down. So the trucks couldn't get in. The whole company was shut down for 2 weeks. It cost them $300 million, and the total costs of worldwide are probably $10 billion. This will be in the courts for years. But the problem is they didn't have the management support to do what they possibly did. The only way they got online is because in Ghana, they had a power outage. So their computer system was offline for those 2 hours, thank God. And so they were able to re-image their entire system based on this Ghanese tape, which they had hand delivered. But the reason that Maersk failed is because they didn't have management support. The management wasn't giving them money to segregate and adequately update and to check which systems they had. So they just didn't have the money. Scope. That's very, very important. What's your risk? What do you owe? Plan. You got to plan what you're doing. If because most of this, if you look at the legacy systems, and I'm not, I don't know all the stories, but I've heard enough of them, is that people are just putting this thing together ad hoc. The technology changes so fast that they don't plan. They just say, oh, I think we need this. And that's not a way to run a business. You gotta, think about it. Communication. Obviously, this is your weak link here. You got to train some more. You got to communicate your things. Risk assessment. What do you have? What do you need? And then once you know what you have, what your risks are, then you can go down your checklists like 53 or Annex A and decide what you want. And then documentation. Why do you want to document it? Well, ISO requires 15 documents, and like the GDPR requires like 3. But the word documentation exists 22 times in the GDPR. So why do you want documentation? Well, that was best said by the Singapore Privacy Commission, and they said, well, if you don't document it, you can't prove it. Then it's just word of mouth. We don't know. You don't know what the hell everybody's doing, and they don't know what's either, because there's nothing that says this is how you should do it. And then one of the most important things here is the testing thing, because just because you have it then doesn't mean it works. The big one there was Equifax. Equifax had a really cool internal prevention system, and it was great, but it was misconfigured. So they found out they'd been hacked, and they went and checked on this thing, and then and it wasn't showing any hacks. Then they reconfigured it correctly, and it went crazy. It's just, and if they tested it, if they planned on it, and they tested it, they could have found this out and saved themselves, enormous amounts of money. And that lawsuit will go on for probably as long as I'm going to be alive. And it's going to cost them an enormous amount of money just because they didn't test. Why didn't they test? They didn't have to test. There wasn't any reason for it. Scope. Okay. Here we're discussing in this webinar, we're discussing a lot about your regulatory environment, probably specifically the SEC or for listed companies. But as we've seen, the regulatory environment, and by the way, I've written 3 books on international law. And normally, quite often, everyone sort of eventually adopts the same law. Like, for example, SEC Rule 10b-5 was adopted in the United States in 1934. Well, it was adopted in Japan 40 years later, and in Hong Kong about the same period of time. Now, with the GDPR, it's not taking 40 years, it's taking 3 months. So your regulatory environment is changing just as fast as the technology, in some cases faster. So you have to be constantly aware of the regulatory environment, especially over the last. It's really been incredible over the last, and I'm the guy who has to read this junk every day. So it's really important that you keep involved and keep that in mind in determining what your system has to adapt to. The other thing you have to keep in mind is, who are your other stakeholders, your clients, your customers, your partners, your regulators. You have to make sure that, what do these people need? And you have to do your risk assessments, determine what sort of asset. You extend your logical system, your network and cloud. I was listening to my favorite computer geek, Johannes Ulrich of this SANS Cloud Stormcast. He was talking about some Microsoft problems with Azure in terms of their DNS and their IP and doing internal emails and various types of things. So you have to determine where you're doing, what are the strengths and what are the weaknesses of the various types of security architecture. And then you have to determine the extent of your physical systems. What offices do you have? Where are these offices? What laws do they come in? Are they offices, departments, or things like that? How far and what is your system and your security system going to cover? And all these questions have to go into, the point is really about a management system as opposed to a SOC 2 audit. The whole damn thing is it forces you to think. Yes, think, I know it's a problem. But we have to think about, why you're doing something. What do we have to protect? Where we have to protect it? That type of thing. Okay, this is your a word from your sponsors. This is our particular risk tool. There are others. I happen to like this one because it's ours. Okay. Now, of course, the most important part of the whole process is, because this is where your weak link is, to make sure that your staff is adequately educated and ensure compliance. We feel at ITG the best way to do this is with e-learning, and of course, we do have modules, of course, that we regulatory. Yeah, I like that. You see, this probably could have gotten better with better staff training, i.e. my spelling. Compliance requires everybody who access collects information. You have to know, who is. I mean, that's the problem with Beck, is quite often there's no, what is it, this two-part identification. I mean, that happened with the Pakistani central bank. They didn't have, they got this fax that said, send $82 million to X, and nobody picked up the phone. They're saying, what? So they just said, oh, it seems like a good idea. We trust the SWIFT system. And then, of course, the money went out the door and down through a Filipino casino, and there the gold scene ended. Because it's, I also, one of my areas of expertise is money laundering. And I can tell you right now, there's a lot of really cool ways to do it. So, but if you identify potential problems with your system and make sure all the employees, and remember, I always got that question on all my exams. They always said, who's responsible for cybersecurity? And the answer was everybody. So you have to make sure that everybody is educated on these things and know their responsibility and are fully aware of the regulatory requirements and also the responsibility for in your particular cybersecurity environment, whatever that may be. Okay, so this is how you implement it. You identify the common drivers. What are the problems that this is? Well, we've always done it this way. Well, you might have to do it something different way. So then you have to provide, and then you have that communication. Implement controls to mitigate aversion to change and reduce risk. My favorite was the Akamai Penguin. And if you were cool enough to do cybersecurity, you got the Penguin for a month. And if you had the Penguin, you were the man. You were the I can't say it on a webinar, but in investment banking, was they had an unfair and off-color way of determining who the big person in the office was. So that's what you could, one of the ways you can do this is with gamesmanship, is that you encourage people to participate this, gives them incentives and disincentives, not just disincentives. You don't want to just whack them if they get it wrong, because then they won't have the incentives to get it right. So you have to make sure that they have the incentives to see these types of risk and to continually improve and monitor the system. You don't want just the internal audit work or IT department worrying about this type of thing. You want everybody to worry about this, because that's the only way you can make sure you have an effective system. Okay, this is another type of stuff that we do. And yeah, we do the GDPR, yeah, that's cool and all that, but it's not about the GDPR anymore, because that's so last year. What we have now is we have a burgeoning, metastasizing global cybersecurity and privacy regulatory environment, regulatory infrastructure. So it's far more complicated than the GDPR, and in some ways it could be a lot more expensive. So although, the people who are always there are two people that are really going to hurt you, and it's not going to be the regulators. It's going to be the hackers, and it's going to be your partners. Because either your hackers are going to steal from you, or your partners are not going to do business with you, your customer. So it's not, I want to express this again and again and again, it's not about the regulators. It's about your partners, and it's about the thieves. Those are the people who you really have to make sure that why it's important to have a resilient cybersecurity system. And I can train you in one of these things if you're unfortunate enough to get me, or you may get there are other types of training programs. So thank God, that's 40 minutes. So I am finished yakking, and right now, if thou wants to, you can ask questions, or you can type a message in the chat audience, or communicate or ask any other questions that you so desire. that I can basically answer it. I can't answer why you are here. And I do not, and I'm not qualified to answer anything about what came before the Big Bang. But other than that, we could feel free to ask any other questions. So I'm going to shut up now, so I'm allowed you people to think for a few minutes. Stop checking your phones. Oh, HIPAA. HIPAA requires a risk analysis. Yes. HITRUST has a checklist. Yes, HITRUST. Well, okay, HITRUST has a checklist. CMS will pass you just because HITRUST certified. Wait, I'm not quite sure what CMS is. The regulator for HIPAA is the OCR. I will look it up because they're HITRUST certified. They require risk analysis. Government basically adopts NIST risk. Yeah, right. You can do the NIST. Right. You can adopt the NIST risk assessment. I'm not really wild about the NIST risk assessment. Of course, I'm sort of the ISO party. I would like the risk assessments for ISO are ISO 27035 1 and 2. There are other risk assessment. My feeling is the best way or the only way to do a risk assessment is with a risk assessment tool. You've seen ours. There are, of course, others out there. The reason why I think a risk assessment tool is important is because it provides consistent and repeatability. Now, I'd have to go back and look at 30 to make sure that's appropriate, but I'm sure that's probably would be. Now, a word about HITRUST. My understanding about HITRUST was that it was just a bunch of people who want to make a couple bucks. And so they came up with a standard that they came up with, and then got a whole bunch of partners to say, oh, isn't this a really cool standard? Now the question is so what? Does anybody else stand up and salute? In my view, probably not. First of all, I question who came up with the standard. At least in NIST, you have a whole bunch of government experts supposed to. In ISO, you have not only experts, but you have industry partners who are coming with this, and it's developed over a number of years. So it has, in my view, it has far more credibility. HITRUST, in my view, was just basically a successful marketing firm, as they were able to say, hey, Jesus, if we come up with this cool certification for HIPAA, then we'll make a ton of money. Now, I don't know that HITRUST ever got, and I don't even think OCR could certify them if they wanted to. So, I have, heavy questions about the viability or the integrity of HITRUST as I understand it. I want to say I'm not an expert. Okay, so what I would recommend, to answer your question, I would recommend getting a risk tool that you are sure complies with NIST 830, and you go with that. The problem with the NIST 830 and with problem with all the NIST products is there's no way to certify that you've done it correctly. So I don't know who's going to come in. I'm not sure if OCR is going to come in and do it. If you look at the OCR protocols, all 158 pages of them, they ask, most of what they do is they ask for documentation. So what I would be sure of doing to make sure that you comply with your HIPAA is to make sure you've documented it, and that's where why you need a tool. Because the tool is going to give you documentation over a time period. So if something, God forbid, does happen with HIPAA, they can come in, you can come in and show, look, here's the documentation for my risk analysis. So you guys can see what we've done, and you can prove it to the regulators. That's true of every regulator. All the regulators are going to ask for your documentation, no matter where they are or what country they're from. They're not going to ask for, well, do you really have a really cool, IA firewall going there, but or AI off, firewall or whatever. They're going to say, well, where are your papers? Show me the paperwork. And so I think that's probably the best way that you can probably prove compliance with that requirement in HIPAA. That would be 145 CFR 164.300. I'm not quite sure what the subpart is, but that would, I'd have to actually go back and read that. Okay. 115. Oh, yeah, it's OCR. Thank you. Yeah, it's OCR, Office of Civil Rights. I'm not sure why the Office of Civil Rights is there. No, it's awful. But if you're an unregulated industry, oh, you're in the unregulated industry, good. I've never seen one of those. Really have no GDPR data. Would ISO be a good? Well, yeah. The question is, I would, before I go with the ISO, because it's expensive, it's a long process. Yes, you can certify to it. You can. The problem is you don't get the certificate. So you can go in, or yes, in England they have this really cool system. It's called Cyber Essentials. The government certifies to. Now the only U.S. product is out there is NIST IR 7621, which is a 50-page book that basically says for small firms about what policies and procedures you can practice to get a good cybersecurity, which of course is a lot cheaper because it's free and you just go down there. The problem is and you can do this yourself. You know, you can spend $110 and get ISO 27001 standard with Annex A and go through it and, you know, do it yourself and say, well, we're self-compliant with it. We've gone through all these standards and we've tried to adopt them ourselves. The only problem is the next question is, do you need the certification? Do your stakeholders, your customers, who pays you money, who you pay money to, your stakeholders, your regulators, your investors? I mean, let's say, for example, you're owned by a private investor group, you're owned by a hedge fund, and well, they're going to say, well, we want to make sure our money is protected, and so they may require it. So that's the question, and then of course to make sure that they require it, they may require you to get the certification. So what you do is, you know, obviously this is expensive. How you allocate your budget depends on what you have, but it really depends on sitting down and saying, well, what are our risks? What do our customers demand? What do our investors demand? What do our partners demand? What do the regulators demand? And then you think about that, and then you say, well, you know, if your investors aren't demanding anything, if the regulators aren't demanding anything, and and if you don't have anything important to protect, then hell with it. But you have to sit. But the whole point of the information system information security management system is to go through the thought process of planning and risk assessment. I mean, if you look at ISO, there are 7 clauses. All right, you go through clause 4, 5, 6, 7, and you don't 4, 5, 6, 7, and you don't really get to do something until you're 8. And then it's 9 and 10. So the first 4, over half the entire process, is really about planning. And that's really the whole point of the system. You got to think this through. You just can't go around adopting junk because it's really cool, or it's, whatever somebody's selling this, or it's the top of the technology thing, or something like that. I don't think that there is, a heavy metal way out of this. I think because, all the hacks are going to be human. So the best way to do it, in my mind, and I must admit I drank Kool-Aid on that, is that you have to manage your people and manage your systems, and most of that is thinking about what you need and how you need it. So no, it's not a softball. It's actually a very complex question. But the real question is you have to think about what you need and then go through it. I mean, I love telling some of my clients, when they come to me and say, well, do I have to comply with GDPR? My first reaction is, are you subject to the jurisdiction of the GDPR? And, 5 times out of 10, or actually 8 times out of 10, they're not. Because I can usually figure out a way to get them out. But that doesn't solve the problem, because, the GDPR was last year. Now we've got a whole bunch of other different laws. So I have to figure out, well, I had one in California, and they said, are we subject to the GDPR? I said, no. But the next question, are you subject to the California Consumer Protection Act? because they were in Los Angeles, and they fortunately weren't. But were they subject to other California and other U.S. laws? Yes, they were. And so because you had to have breach, protocols. So you have to think about that. So and then they have to have good cybersecurity. And the question is what information they have, and if they have secured information that they could get sued over, then they better think about a more robust. It's not just having a robust cybersecurity system or hardening your things. You got to prove it, because you've got to prove it to somebody. You got to either prove it to your customers, your investors, and God forbid regulators, and even worse if you end up in a court. So that's the whole business of why the system is better. Why any system, any documentation system, no matter how small it is probably better than none, because it forces you to think through the system, and then it forces you to prove that you have the system to everybody else. Anyway, it is now 2 o'clock, and thank God I can shut up. Hopefully, if you signed up for this thing, you will get some of the seminars, or you can contact us on any of the normal things. So other than that, I am going to sign out and say thank you very much.